Good morning, everyone. Thank you very much for coming. Michelle Fideli from First 5 Marin Children and Families Commission. And this is our monthly event, the Marin Communications Forum. And we're so glad to have you with us today to learn more about legal rights for working parents. And we have two expert speakers who are going to be sharing a lot of information with you. And we will begin with Katie Witchett from Legal Aid at Work. Katie, do you want to use? Sure. This? Do you want to be at the podium?
Yeah, that works for me.
Okay, great.
Can you hear me? Is this good? All right, good morning, everybody. My name is Katie Witchett. I'm an attorney at Legal Aid at Work. And so what Legal Aid at Work is we're a nonprofit that provides free legal services to anybody in anything related to employment. And then specifically within that, I focus on work-family issues. So the issues that come up at work for new parents, for people who have family members with health conditions they need to take care of, and for people who need to take care of their own conditions while also having to support themselves and support their family. So as background about my organization, we kind of try and use all the strategies we can think of to help people keep their jobs while being able to support themselves and their families. So we have a helpline that we get maybe a few thousand calls a year, and an attorney or a law student will call anybody back within a couple of days and answer any questions they have about their work. Even if it's just, okay, like how much time do I get to take off? I just had a baby. Or, okay, I'm taking time off, my partner's sick. Is there any way I can get paid during this time? Sometimes it's more complicated. Maybe somebody's lost their job because they needed to take time off, or they tried to come back to work after their pregnancy and their employer said, no, we don't have space for you. And just depending on the circumstances, we can help people to understand their rights. We can help them to figure out how to talk to their employer. Sometimes we contact their employers for them to try to help them get back to work. And it just depends on what that family needs. Sometimes it's just information. Sometimes we file a lawsuit. So it's very flexible, just depending on what that person thinks is right for them and their family, because they're the one in the job and they're the one in that situation and they know best. So on top of that, we try to provide education generally, because if you don't know about these rights, they're not very helpful, are they? And we also do a lot to fight to expand these rights. Because one of the things that you'll see as we're going through this is there's a lot of places where it doesn't really make sense. There are situations where, somebody's, like let's say your spouse has a stroke and you need to take 2 weeks off from work to take care of them. There are certain people who can still be fired for doing that. Or certain parents who, even if they want to take 2 weeks off with their new child, who can still lose their job. So there's a lot of space to move. And it kind of impresses again just why it's important to learn about these things, because it's not necessarily intuitive. It's not what you think. There are things that would make sense that you might not legally have the right to do at your workplace. So employment issues can be kind of complex. You don't need to know all of these laws. It gets confusing for everybody, including me sometimes, but what we're going to do today is we're going to focus on a few basic areas of protection that kind of apply and are important to everybody who has a baby, to every parent, things that come up for them. So there's 4 main categories that I like to break it down into, just to kind of simplify things and have a framework to think this through. So there are 4 types of rights that people have at work. And one is the right to take time off from work where your employer cannot hold it against you, and you can come back to the exact same job that you had beforehand. A second is the right to get paid while you were taking that time off from work. Because what you'll learn today is that there are times where you can take time off and your employer has to hold your job, but that doesn't mean that you're going to get money during that time. And there are also times where you might be able to get money from the state, But when you try to return to work, your employer can say, what, you were gone, your job is gone, we can't have you back. Beyond that, people have the right to not be discriminated against based on pregnancy. And then finally, people have the right to get changes at work for their health and for their pregnancy. So those are the basic four. Just keep them in mind and we'll get through them. So starting with pregnancy discrimination, this is a basic one. I think we all know, employers should not be discriminating against people based on the fact that they're pregnant. But it really can happen in all kinds of forms. It can be employers kind of making snide remarks and being like, whoa, can you keep doing that? Like, you're pregnant, do pregnant people really need to work? Like, shouldn't you be at home? Employers can't fire for people for being pregnant, and that includes no matter what their motive is. You'd be surprised how often I hear from people who say, well, my employer said, like, I'm pregnant, I just shouldn't be working, and it would be better for me to put my feet up. It's easy for the employer to say when they're not the one who has to support that family. So no matter what the motive is, no matter what the reason, if an employer is treating somebody worse because they are pregnant, that's something that is against the law. The second main category is pregnancy accommodations, and this is an important one. So we're very fortunate in California in that if somebody works for an employer with at least 5 employees, it doesn't matter if they started work yesterday, it doesn't matter if they work only a couple of hours a week, they have the right to get changes at their work for their health. The only limit is that it has to be something that a healthcare provider recommends and says is medically advisable. So if somebody asks for these changes at work and they don't have a medical note, the employer can say, sorry, we're not going to do that. But with a medical note, suddenly it becomes this obligation where the employer has to make that change so that person can keep working and still continue to protect their health. The only limit that comes with this is that if it gets to the point where somebody cannot perform their work at all, their employer can say, you can't do your job, and potentially ask somebody to go out on leave. So that's one of the reasons that what we always recommend is that if you're a pregnant parent or if you're talking with a pregnant parent, really think about what that person's job is. What do they do from day to day and what specifically is hard for them? Because if you tailor this request to whatever the limitations are that they have, it's a lot less likely that the employer will have an excuse to say, okay, you can't work. One of the things that I see pretty often is sometimes people will have just like a standard note for pregnant workers and they'll say, okay, like 15 pounds and like X number of breaks. And that can be good, but it's important to talk with the worker specifically just to make sure that there's not something specific in their job that's difficult for them to do or something that makes it so that they can't perform their work. So it really can be anything. It can be lifting, it can be wearing different shoes at work, it can be taking breaks, it can be working different times of day, anything that that person specifically needs. So it's very flexible. So one of the most important, these are two of the big categories of rights that get the most confusing. So it's the right to take time off from work, and then the right to get paid while you're taking that time off from work.
Too fancy.
I know, my PowerPoint, high tech. But I want to draw this out just because it's important to remember that they are two separate things. Because so often I hear from people who assume that they're one thing. That you just need to talk to your employer and that's it, or you just need to talk to the state and that's it. But generally, for most people, if they want to take time off and they want to get paid, they need to be doing both of those things. So I'll keep going back to that, but I'll say it far too many times before today's done. So I want to start with time off for people while they're pregnant. So we're going to go chronologically in talking about time off and getting paid. So in California, we have a law called Pregnancy Disability Leave. And what it does is it allows someone to take up to 4 months off while they are pregnant, but it's limited to while their healthcare provider says that they are unable to work because of their health. So what that means is, while it can be up to 4 months, for most people it won't actually be 4 months. Typically, 4 weeks before somebody has a baby and 6 weeks after, 8 weeks if it's a C-section. It's pretty universally recognized among healthcare providers that that is the time that somebody is disabled by their pregnancy, no matter their job and no matter whether there are any complications or not. But because it can be up to 4 months, there is that flexibility for people who have a more complicated pregnancy, or people who have work that's more difficult for their health and they need to take more time off. This can be used for prenatal appointments, it can be used for morning sickness. Again, the only requirement is that there's a note from a healthcare provider saying that somebody is unable to work because of their pregnancy.
Does postpartum depression fall into that?
It does, yeah. Postpartum depression falls into that. So any health condition related to pregnancy can fit. And this right, it applies to almost all pregnant workers. The only requirement is that they work for an employer who has at least 5 employees. So someone can have started work yesterday, they can work 4 hours a week, it doesn't matter. If they're an employee and their employer has 5 employees, they are able to take this time off. And so this is different than in most of the states. So if you're ever working with somebody who works for like a big corporation, or like retail for something like a chain that covers the country, oftentimes they get confused about this because this doesn't exist in most places. So it's a good thing to keep an eye on. And one other point that I want to make is that, so when it talks about people being disabled by pregnancy, there's no specific definition of what that means. It's not this high standard like, oh, does somebody need to be on bed rest? It's just if somebody can't perform their specific work. So if the pregnant parent works for, let's say, FedEx, and every day they have to lift boxes that are 50 pounds, and that's what their work is. If they're employed, if they get a note that says, okay, she can't lift more than 40 pounds, and her employer can't find a way for her to do her job with lifting no more than 40 pounds, she counts as being disabled, and her job is protected while she takes that time off. So it's just specific to their specific position. It doesn't have to be, something hugely disabling, bed rest, anything like that. It's just their specific job. Can they do it? If they can't do it, their job is protected. So obviously this leads to the next important question of, okay, so you can take time off from work, but how do you get paid? Because if you can't get paid, it's not necessarily something that somebody's able to do. So in California, we have a program called state disability insurance. And what that is it's something that everybody pays into out of their paychecks, like a tiny, 0.1% of all the income that somebody gets. Basically, all private employees goes into this fund, so that if there's ever a time that someone cannot do their job because of their health, they can apply for this at the EDD, and they can get 60% of what they'd be making if they were working. There's a few people who get 70%, but the threshold is so low that generally I just tell people to assume it's going to be 60%. And so one question that always comes up here is because, so this is a state program, you have to apply to the state, is whether or not this is something that people can get if they are not a citizen of the United States. And the EDD has said for years that citizenship does not matter. And recently they put it on their website in big bold writing just to make sure that everybody knows that citizenship does not matter. When you apply, it does ask for a social security number. But the reason it asks for that is just to track what money it is that you have paid in. So if somebody's working under a number that isn't theirs and they apply, they still have the right to get that money, and the state has said it's not important to them and they don't care. They just use the number to track the money. And it can be intimidating, so it's not a perfect system because people don't want to apply. One second. And sometimes it can be more complicated because if multiple people are using the same number, the EDD won't just say yes, they'll send a really scary letter. So I see nods, a lot of you have gotten this letter that says go to the Social Security office and prove who you are. They send the letter, but you don't have to do that. All you have to do is send in a pay stub something to show that you were the one who was working at this place, and then the EDD will pay. But, you know, it is really unfortunate because so many people, they get that letter and they think, okay, this isn't for me, and they stop. So even though they've been paying in year after year, and it's all of their money going to this fund, they're never able to get it back. So if you ever talk with somebody and they're confused about the process or scared about the process, feel free to call, and I'm happy to talk and walk through that too. But people are allowed to get it no matter what.
How does this apply to illegal residents?
To
To someone who has, I'm sorry, who's not, who's undocumented,
Who
sorry.
is or not?
Is documented, and then what about if they're undocumented?
so
So
it,
you said citizenship, there's
Oh, yeah.
citizenship.
so it doesn't matter what
Their legal citizenship.
what their legal status is at all.
Okay.
The only thing is that it tracks with what money has been paid into the system and using a social security number. So if somebody has given their employer any number, they should be able to get this. But like if somebody's getting paid in cash, you know, their money's not going into the system, so they won't be able to get anything. But I'm glad you clarified that, yeah, so.
Can you retroactively get the money if you were pregnant and then didn't know about this and you stopped working?
Yeah. No, so that's a good question. So typically they want you to apply within 49 days, and if it's longer, they make you say a good reason that you didn't apply earlier. But generally if you say, you know, I didn't know this existed, I didn't know I was eligible, they'll take that to be a good reason. So really if anybody took time off for pregnancy within the last year and a half, I encourage them to give it a try, because worst case scenario, the EDD will say, no, you're too late. Best case scenario, you end up getting 10 weeks of pay all at once from the money that you've been paying in. Yeah?
Would it make a difference if there's a medical letter? Because we get patients sometimes like that, and we just write letters saying for what reason the person was not able to apply on time, and we assume that they will get it, but does it make a difference or it doesn't really matter?
So that's a good question. I mean, you need a medical certification saying that the person's not able to work.
Right, which
But I haven't, I don't know if having the note from the medical provider saying the reason that they didn't apply earlier makes a difference or not. You know, I think it would certainly not hurt. You know, people respect healthcare providers, so if that's something you want to do, I think that's a great thing. But I don't know if it actually makes a difference or not in whether or not they accept it. Okay. If you think of questions later, feel free to throw your hand up, even if your slides pass. So in addition to being able to take time off for health and for pregnancy, people also have the right to take time off to bond with a new baby. And this applies to both parents. It's the same right that allows someone to take time off if they have a sick family member who's seriously ill. And it's also the same law that allows people to take time off for their own health condition when it isn't related to pregnancy. So in California, it's the California Family Rights Act, and it gives people 12 weeks to bond, 12 weeks to take care of sick family. But the difficulty is that it doesn't apply to everybody. It only applies to about half of workers. So there are 3 very strict criteria. It has to be that somebody has been working for their employer for 1 whole year, that they've worked 1,250 hours within the last year, and that their employer has at least 50 employees working within 75 miles. So it's a great protection, 12 whole weeks, that's really wonderful, but right now, a lot of people are not covered by it. Did you have a question? Oh, okay. But I do want to highlight how the law is moving forward. So while generally it's 50 employees for a sick family, for your own health, starting in, I think it was 2018, so I guess it's a while ago now, but it still feels yesterday. There was a new law in California that lowered the employer threshold to 20 employees. So starting in 2018, employers that have 20 or more employees working in the area also have to let their workers take 12 weeks off if they have a new baby. And again, it's both parents or either parent. So this is a significant new right. It covered about 3 million more Californians. And it's something that a lot of employers don't know about, especially smaller employers, because it is so new. So it's something that is always good to raise with a new parent. And you know, even if it's a lot of times it's the person who's pregnant who's coming in, I always make the pitch, talk to your partner, bring them these materials, talk to them about it. They can take time off and get paid and help raise the baby too. But it's a good one to make sure that everybody knows about, because their employer might just be completely unaware. It might not be that they're saying, okay, I don't care what the law says, you can't take time off. The employer might just have no clue. So, good.
I was gonna, maybe you're gonna say that now, but does that leave have to be continuously, or does it have to be
That's a good question. It can be broken up.
broken up?
Yeah. So an employer can limit it to 2-week increments if they want. So, you know, if you went to your employer and you said, okay, I want to take off every Friday for the year, the employer would be able to say, okay, how about take 2 weeks off, or don't take time off. If you're taking time for taking care of like a sick family member, then you can break it up however that person's health needs. But if it's for baby bonding, the employer can say 2 weeks. Yeah. So of course then there's the question, okay, can you actually get paid during that time? So California has a program called Paid Family Leave. And so the name says it's called Paid Family Leave, but I want to encourage you to think of it in your mind as Paid Family Insurance, because it doesn't give anybody the right to take time off from work. It's just a way to get paid. So just like there's state disability insurance for when somebody's disabled, there's paid family leave insurance for when you're taking time off for somebody else's health. And so what it does is it allows someone to take 6 weeks of pay from the state at the same 60 or 70%. If they're bonding with a new baby, or if they are taking care of a sick family member. Another exciting development is that, so starting in July of 2020, it's going to be 8 weeks instead of 6 weeks. But it only applies to people who start their claims in July or later. So for anybody who's having a baby within the next 6 months, if they take paid family leave now, they're going to get 6 weeks. But if they decide to wait until July, they can get 8 weeks of pay instead. So this pay can be gotten anytime within a year after the baby is born. And so this is one of the places where there's the biggest confusion, because so paid family leave, the only requirement is that you've paid into the system and you are taking time off of work to be with a new baby. So, you know, most workers, they do qualify. They can get this money. But like we were talking about earlier with the California Family Rights Act and the ability to take time off from work to bond, you still have to have that employer with 20 to 50 employees. So for that person who works at an employer with 10 employees, or like let's say they started their job within the last year, or they only work, you know, 10 hours a week, if they take time off from work, they can get paid, but their employer is not required to hold their position for them if they take that time. So I want to quick go over this. So these are, we have a couple of charts that just show how all of this fits together. So this is a map of what leave and pay looks like for a typical pregnancy. So 4 weeks beforehand, somebody is disabled from working. They're covered by pregnancy disability leave. Their job is safe. They're unable to work because of their health, so they can get state disability insurance. That continues for 6 weeks after they have their baby, while they're just recovering because of their health. And then after that, if they qualify for the California Family Rights Act, they can take 12 more weeks to bond with their new baby and get paid for the first 6 of them. And then this is what it looks like for the parent who doesn't give birth. If they work for that employer that they've been at for a year, they're working over 25 hours a week, which is about 1250 hours in a year, and their employer has at least 20 employees, they have the right to take 12 weeks off, and they can get paid during 6 of those weeks from the EDD.
And soon 8.
And soon 8. Yeah. Okay. And I think, how much time do we have? I don't want to go too long. Let's see.
We're fine.
Okay. Okay. Go ahead.
Can we get slides? The slides?
Yeah.
It's a lot to.
question?
Yeah, of course, yeah, I'm happy to send
So
those.
I'll get them from Katie and then I'll email everyone, so as long as you were registered. And if not, we can connect.
So I do want to talk about lactation accommodations. So for a lot of new parents, when it's time to go back to work, they're wondering, can I keep pumping? Can I keep breastfeeding my baby? What does that look like? And everybody does have the right to take whatever breaks they need in order to pump at work, and a private location that is not a bathroom. So there's no strict line for how much time they get to take, because everybody's different. It's specific for that reason. And the only other requirement is that it's not a bathroom. So as you can see, like, this is a pretty low threshold. This is what it is across the country. You know, I've spoken with people who've been told to pump in supply closets, and technically that qualifies. But fortunately, this last year, a new bill went through that has changed that a little bit. Could you do the next slide, please?
Next slide.
Oh, sorry.
That's okay. So, happy thing, in around, I think it was October, the governor signed a bill that advocates have been working on for a couple of years to expand lactation accommodations. And it's a big fight to get this through and to get everybody to vote yes on it, for the great luxuries that it has to be a clean space, there has to be a place to sit, there has to be a surface that you can put a pump on, and there has to be access to electricity and to water and refrigeration nearby. So I mean, this is kind of what you would hope the minimum standard would be, but this is actually the leading standard around the country right now. But so this is only going to start at the beginning of 2020. Right now, it was based on the San Francisco law, so right now this is the law in San Francisco. But starting in 2020, all employers will need to do this. So as you can imagine, when things change, a lot of employers will not be aware that this is what their obligation is. So it's important to share this with the new parents that you talk with. And I know it can be difficult to go to your employer and say, hey, this is what the law is, you need to do this. So everyone should feel welcome to send people my way, and we're happy to come up with materials and share some of our materials to come up with ways that are a little less intimidating to educate employers that people can go back to work, they can pump, they can take care of their health. Yes?
For this law, it said that a reasonable amount of time to be able to, breastfeed or pump. So I have a lot of families who like live somewhat close to their childcare facility, and so does that also, do employees, like, they can't really, there won't be an issue if parents go to the school to breastfeed and then come back? I mean, obviously that would be a longer than, like, what it would take because there's transportation involved.
Yeah, I mean, so that's a good question.
Come across that.
There's not.
Can you repeat it for everyone?
Yeah, so the question is, what if somebody wants to leave work to go breastfeed at school nearby? And so there's not a clear answer on that yet, on whether that qualifies within the time that somebody is allowed to take breaks for the sake of breastfeeding. There is law saying that, like, if somebody brings the baby to work, that's one way that you can breastfeed at work, and that your employer has to let that baby come to work so that you can breastfeed it. But whether or not you can actually leave to do that, it's still up in the air. So for the sake, go ahead.
Yeah, sorry, so just out of curiosity, you said that this was obviously faced with a lot of opposition. Who was opposed to this? I mean, seriously, like, who really, was it employers, was it even on our own legislature? Why was this such a hot up battle?
So the Chamber of Commerce so there's, like, a lot of employers that they get nervous when there are requirements placed on them, and then there are, like, groups of employers that work together, like, and that have problems with it. In the end, I think they took off their opposition, but, like, we saw people who were concerned who owned restaurants or construction. There was actually, like, it was a really kind of powerful experience where we were trying to move this bill along, and someone from like the construction industry came to us and they said, you know, we're a subcontractor on this site, like how do we know that there's going to be a place that people can pump milk? This is, you know, this is too much for us, there shouldn't be this law applying to us in construction should be special. And, you know, we talked with them and we said, well, you know, there are women and there's not a lot of women working in this industry because, you know, it's difficult for their health and because they're not being given a place to pump. And so what they did is they went back and asked some of their representatives at different sites, you know, is this something that they've come across? And they heard from one woman who had been working on a construction site and she didn't have anywhere to pump, so she had just been using pads all day in her bra the whole time because she just assumed that there was nowhere for her to pump and it just wasn't available. And when the advocate from the construction group heard about that, they realized that this actually does apply to their workers and that, you know, they were talking about how they don't have that many women, but they were like, we want to have women working in our industry. And, you know, maybe this is actually part of the reason. So they came back, they worked with us, and that group actually signed on to be supporters of the bill and to write a letter to the legislature saying this is a bill that we support. So I think a lot of the time this is something that some employers, it's just never occurred to them. And so another part of the law that's great is it's requiring employers to come up with a policy and to share that policy with every new employee, as well as every employee who asks about taking pregnancy leave or bonding leave. So to put it on the employer to actually educate themselves to know that when people come back to work after having a baby, they might need to pump milk, and they need to have a plan for that, as opposed to putting it on the new parent to come back day one and to try and figure out how to deal with the situation. Yeah. Okay. So, it's okay. So we'll send the slides around, but there are some other protections that we don't need to go through for the sake, because I could go on all day. I mean, I could. But people have the right to a couple of paid sick days. There is a law that allows people to take time off to sign their children up for childcare or to go on field trips with their kids if their employer has at least 20 employees. Also, it applies for like childcare emergencies. So you remember a few weeks ago when the power went out everywhere. So like if power goes out at the daycare can't take the kids. Parents have the right to take that day to take care of their children in that emergency, and their employer can't hold it against them. And then also, it's a little bit of a tangent, but I'm sure it's something you've seen come up a lot. Domestic violence. So people who experience domestic violence also have employment protections, where if they need to take time off because of their safety, to go to court, to go to safety planning, to seek a shelter, their employer can't hold it against them. And if anybody has questions about that, I'm happy to talk more at a different time. So there's new changes on the way, and I'll say this because we'll continue talking, but it's been a good year, and the governor has shown that he cares about paid family leave, and that's something an area where we need to see improvement. So it's a good moment in time to stand up and say paid family leave matters, because things are moving along more quickly than they have in the past. So just as some kind of top bullet points to think about when you're talking with new parents. If somebody is having a lot of health complications and they might need a lot of time off from work, make a note of it and maybe give them our phone number, because the longer the time is, the more complicated it is, the more laws somebody needs to put in line. But generally, you know, if the reason somebody cannot work is because of their health, their job should be protected, and there are things that you can do to make sure that they can come back to work when they're ready. For changes at work, talk with the person about what their job specifically needs, so that when you make recommendations, they can be specific, or when you make requests, they can do what you need. And then for taking time off for disability and getting paid for disability, it doesn't have to be that somebody's completely disabled, it just has to be that they can't do their specific job. So even if somebody's perfectly healthy in their pregnancy and they work in a place where there's pesticides or something like that, so they shouldn't be for their health, but that's enough to qualify as being disabled. And if you have any other doubts or questions, we're here, we're happy to talk, we do it all the time. And so our website has a lot of videos on these things in different languages. And we do our best to come up with guides and tools that make this as easy to understand as possible so that people have a place to start. So I think everybody has a roadmap at their table, but I also brought some copies in Chinese and Spanish if anybody wants them. And we also I brought some copies of our Pregnancy Plus My Job handout. And what this one does is it goes specifically through, all of these laws to explain when people can take time, when they can get paid. And I know lots of lawyers and healthcare providers who just have a copy at their desk so that when questions come up, they can refer to it.
And we can provide that to you electronically so that you can make copies for clients.
Thank you. So that is it, and if you have questions,
Yeah.
feel
That was
free to contact me.
a lot of information and a lot of questions, so we wanted to allow you time to ask questions of Katie. Would anyone like to ask something? So Katie, I'll just start off one thing. If you mentioned those various situations, if someone is going back to work or has questions, they can contact your office, but do you have someone that can advocate for them or advise them or go with them or send a letter? How would that work?
Yeah, that's a good question. So it always just depends on that person's specific situation, because people have different comfort levels. It should be that you can talk to your boss about what the law is and what your rights are, but sometimes, that can hurt the relationship, or, sometimes people know their job best and how their employer might respond. So like in in an example, I've had people call who they're going back to work, but their employer's not giving them all of their hours. I might help them to write a text or an email that they can send to their employer coming from them, just kind of saying, hey, I'm coming back to work. It's my understanding that I get to return to the same hours in the same position that I had before. I'm confused about what's happening. If you don't agree with that, can we talk? Could you please just put me back in my job? And sometimes that's enough. Sometimes it's not. If it's not, they can let us know, and sometimes we write letters to employers saying like, hey, you broke the law. This is what you did. You need to let this person come back to work. And sometimes the employer will call within a week and say, okay, sorry, that was our mistake. You can go back to work.
But maybe best to start off in a friendly way with just a question or a request, and then elevate to getting legal assistance.
Exactly. So like we're happy to help provide our legal advice for how to make that friendly ask, and how to start low, and try and
You have a colleague.
But so yeah, we're just always very careful to talk with the person, because they're an expert about what their family needs. They're an expert about what their boss is like. I know what the law is, but they know what their workplace situation is and what things they're worried about specifically. So it's a collaborative process. We talk things through, and hopefully things can be worked out in a friendly way. But if they can't, we're there for each level of escalation. So whether it's writing a letter to the boss, filing charges with state agencies, filing a lawsuit, it's best for everybody if things can be just resolved quickly and at the front without any hurt feelings. So that's always the goal. But we're there when that doesn't work out too. So that's something that I always want people to know also, because it can be scary to talk to your boss. But I think if people know that, okay, if it goes wrong, if something doesn't go how you want it to, that I and my legal team are here, that there is support to keep pushing for their rights, that can be something that hopefully provides at least some level of comfort, as scary as the process might be.
Great. Thank you.
All right, thanks everyone.
Thank you, Katie. So now we wanted to continue and welcome Jennifer Reich from Equal Rights Advocates.
Thank you.
Thank you, everybody, and I'm sorry that we had to switch the order around, but that was a really amazing presentation by my colleague Katie, and I'm really happy to be here. As Michelle said, I'm Jennifer Reich. I'm with the nonprofit organization, civil rights organization called Equal Rights Advocates. I'm the legal director, so I'm a lawyer also. I'm also a working mom. And was very proudly raised by another working mom, Amy Reich, who's here. So we have multiple generations of working parents, and so I'm here today to sort of talk a little bit about, you know, why do the legal rights of working parents matter? Why are we all here today to learn about these things, and where are the biggest gaps which represent the biggest barriers to economic security for working parents and families, and where are the opportunities? And I hope that I'll be able to continue to take this sort of bigger picture, high-level conversation back to the ground level a little bit with Katie afterward, when we can engage in a little bit of dialogue about what some of the upcoming, recently passed legislation and upcoming changes to the law that we can look forward to in 2020. Mostly here, focusing on the changes that have happened here in California, but also mentioning a few things that are happening at the federal level, or could possibly be happening at the national level. To begin with, you know, working parents. Who are we? Well, we're most working people, and most parents are workers. So the issues facing working parents, the gaps in our policies and in our employment practices and in our culture that don't support working parents are a detriment to all of us, to each of us individually. We feel it. And we feel it in the stress of the lack of those supports and protections and rights in our families, and that radiates out to the community and to our economy as a whole, really. Because, you know, working parents, we are raising the next generation, and increasingly in this country, most children now are raised by parents who are both, one or more parents who are both working. We don't have a society anymore. We never really did. In fact, it's never been the case that that women's participation in the workforce wasn't significant, much more significant than I think we all recognized. But especially now, we've seen a tremendous growth in the percentage of children that are raised by breadwinning mothers. And so my organization is a gender justice advocacy organization, and so we see these issues from the lens of gender equality in employment and education, but we also know that there's no such thing as equality without any real security, and you can't having equal opportunity to an insecure job and a poor quality job is not really worth very much. So, you know, when we actually, just a little bit about my organization first to give you background on why I'm talking about these issues in the way that I am. We, like Legal Aid at Work, we represent workers in legal matters. We provide direct advice and counseling assistance and other legal services through our national toll-free advice and counseling line. And I can provide more information about all of the things that we do afterward. And I have business cards, as well as I can tell you what our website is. And we advocate for women and gender-expansive people on the job when they are facing discrimination. And we also advocate in the legislatures, especially here in California, where we chair a coalition called the Stronger California Advocacy Network, which brings together groups as varied as Parent Voices and the Domestic Workers Coalition and the Western Center on Law and Poverty, Legal Aid at Work, and other advocates for working families to really push for policies at the state level that will protect and advance the economic security of women and working families. Just as a context here, I mean, we are living in the United States of America, which, as many of you may already know, is the only industrialized country in the entire world that does not provide paid parental leave.
Yes.
So that's one thing. And paid leave for family and medical reasons is so important, not only to people at an individual level, but as I said, to our economy as a whole. And we are, and the people who lack any of the protections that Katie has talked about here are disproportionately likely to be the lowest income workers, disproportionately likely to be workers of color, and our federal law is really anemic, to say the best. It is really weak. It took over 9 years of advocacy to get the Congress to pass the Family Medical Leave Act in 1993. Over 9 years it was introduced and defeated. And when it was finally passed, it was the first time that the United States actually had a policy that guaranteed some workers some unpaid time off from work if they worked for very larger employers and if they worked a certain number of hours in a year. The most recent study that was done by the U.S. Department of Labor shows that 59% of the workforce in the United States is covered by the Family Medical Leave Act. That means 41% of the workforce is not. And if they don't live in a state like California, whose family rights law is a little bit more expansive, but not a lot more expansive than that one, then what you still have, bottom line, is millions and millions of workers who are not covered by this basic protection, who cannot take any kind of job-protected leave, who have to risk losing their job, not to mention losing their source of income and being able to support their families, pay their rent, keep food on the table, when anything happens medically to themselves or a loved one, or when they do what 80% of working women do in the course of their lifetimes, which is have a baby. So we have a major gap, right? We don't recognize at a very structural, sort of systemic level in this society, we do not recognize that the needs and the rights of working parents are really essential to our economic security and then in turn our economic freedom, our freedom, period. Not to get too highfalutin, but I am reminded of the speech that Franklin Delano Roosevelt gave back in the 1930s when he talked about the 4 freedoms. And one freedom was the freedom from want. And so the key to understand is that working parents are actually the most likely kind of working adults to be living in poverty in California and more broadly in the United States. And so we have to understand that the issues, the legal rights and issues that are facing working parents include basic things like an income that can help you survive. You know, people, what legal rights and protections do working parents need? Well, they need a living wage. They need to get paid. They need to make sure that for whatever work they're doing, that they are actually protected by minimum wage laws, which currently in much of this country do not apply to many, many, many workers, like domestic workers, like many of our minimum wage laws, and like tipped workers. You know, the federal minimum wage for workers earning tips is $2.13 an hour. So, and it's not a mere coincidence that the industry that employs more women than any other industry, which is the service industry, the restaurant industry, is also the one with the highest rates of poverty among the workers that are in that industry. So to address the needs of working parents, we have to look at that base level of the pyramid of needs, you know, and think about what it will take for working parents and people with caregiving responsibilities to have some baseline level of economic security, and that would include, among other things, a living wage and access to a job that pays a minimum wage and that's protected by those laws. People also need to have access to quality jobs. The jobs that people work need to actually be fair and safe and respectful, where they can go to work and know that they will not have to put up with sexual harassment as the price of a paycheck, where they can go to work and know that their gender and race is not going to impede their opportunity for advancement. They need jobs with reliable schedules. They need to have a job instead of 3 or 2 to make ends meet. We talk sometimes a lot in the sort of, I hear a lot of talk, you know, because I'm a lawyer and in the legal profession, there is a terrible culture of overwork, which is pernicious in lots of parts of our society, but it's really bad among lawyers and nonprofits. So we talk a lot, because all of us are feeling that, we talk a lot about the need for flexibility. Flexible schedules, we need to have flexibility so that parents can take time off. And it's true, it would be awesome if everybody had that kind of flexibility. But the reality is that the vast majority of working people and working parents in this country, before they even think about flexible job hours, they need to be assured that they're going to be able to get more than 19 hours a week from the employer that they have. They need to know that their employer is not going to change their schedule every 2 weeks, totally unpredictably and arbitrarily, so that they can actually plan childcare, so that they can try to avoid having to take time off from work for medical appointments by scheduling them around their schedules. But if workers don't have fair and reliable schedules, they can't do that. So there are, as we'll discuss, perhaps touch on at least in our discussion, there are a number of measures that have been either introduced or are being pushed right now at the local level and at the state level to guarantee fair and reliable scheduling. But it's another way in which, for any of these rights and protections to sort of be meaningful to people, they first have to actually have access to jobs that pay them a decent wage, a minimum wage that isn't a poverty wage, because everyone knows that you can work full-time, year-round, and earn minimum wage, and if you are a person who has 2 children, you are living in poverty. That should not be the case. So advocacy for working parents and our rights as working parents has to include not just advocacy for benefits that we all should have and enjoy, but also to raise the floor, if you will, for everyone, because we all need it for our economy to work and for children to be able to live in stable environments. We also know that working parents need, of course, they need access to affordable and quality childcare and early childhood education. That is, there is no right under the Constitution or under state law that gives anyone the right to access childcare, but but there is plenty of precedent elsewhere in the world for making access to quality childcare universal. We are seeing some positive steps in that direction, but the progress has been very slow, incremental, and still, again, there are huge sectors of the workforce, especially parents that don't work in sort of conventional hours or industries, where there are just tremendous gaps in access to that crucial service. And really, I mean, none of us, I wouldn't be here today if it weren't for my ability to access childcare. And I couldn't have, even a professional person, lawyer, I could not have afforded childcare if I had not had the support of my family to all help pitch in. That's ridiculous, okay? Yes, question?
Yeah, my question is, what do you do with corporations like Safeway, who play games with the union contracts that state that how they play games with their hours?
Yeah.
They say 25 hours or less.
To get
they're not
benefits.
considered benefits.
Right.
And they can play with your schedule. So week by week, by day, person never knows what their schedule is.
Well, that's exactly why I was saying before that, you know, having access to reliable schedule, a fair and reliable schedule, is a key right that actually they're pushing. For example, in Los Angeles, there's a fair scheduling ordinance and a whole campaign that in fact, some of the key leaders of that campaign are the members of UFCW Local 770, which represents a lot of grocery workers, grocery store workers. But you know, workers for retail are especially very, very likely to have those unpredictable schedules. Fast food workers, very likely to have those kinds of schedules. There has been an attempt to introduce legislation on that issue at the state level a couple of years ago. There's actually an ordinance in place now in San Francisco that they were trying to sort of spread to the state level. And as you know, you might imagine, San Francisco is seen as a bit of an outlier in many respects, so politically it just wasn't like the right time to push that yet. But now, I think with this Los Angeles ordinance, there might be some promise. And I would also, your question also raises something which is really key, right? Like, we only have about, at this point in this country, while we've seen the rise in breadwinning mothers, while we've seen a sort of plateau in the participation of women in the workforce since the 90s, we've also seen a gender wage gap that is as persistent and pervasive as it has ever been, and hasn't really moved for close to 20 years. We have seen a precipitous decline in the percentage of workers, public and private, who are represented by a union, who have access to the ability to bargain collectively about their workplace protections and benefits and wages. And that, there is absolutely no question that when you have the ability to bargain collectively, you improve working conditions and wages. And that is why one of the greatest, successes of this year, policy-wise, was the legislation that will allow child care workers in the state of California for the first time to actually unionize and to actually bargain collectively, because we've had child care workers in this state for years. The subsidy levels that the state sets have been so low, and the hurdles that they require parents to go through and the providers to go through to even get the subsidy for providing child care to working families. So many hurdles and bureaucratic battles that effectively you had women, almost all, 90+% of child care providers are women of color in this state. You had women earning $5 an hour after all was said and done, when they account for how much they had to spend on providing the care, including paying their own employees or assistants. So, we have sort of a system right now that is just fundamentally not working. And so by providing some ability for workers to act together collectively in some form or fashion, it is key to, again, raising the floor for everyone and ensuring that actually access to affordable quality childcare is something that can happen. Yes?
That child care provider, is that a new law in California?
Yes, it was signed this fall.
Can you tell me what that law is
The
called?
bill number?
Yeah,
Yeah, I will look it up. I don't remember it off the top of my head, but I will look it up and let you know after I can check my phone. Yes, what was the question?
Well, I belong to a lot of unions, or local 39 and 786 Teamsters. The unions in Southern California sold the people out. That's what ruined the contract with Safeway. The union did not represent the people very well.
Well, I don't know the history of the bargaining. I do know that there was a strike earlier this year, and that it's been a real struggle in part because of the huge changes to the retail industry. There are enormous pressures on, sort of brick and mortar places like Safeway and Albertsons, Amazon Prime and other places like that are really, there's a whole conversation happening about sort of where employers and workers fit in this future of work. There's in fact, the governor actually convened a task force this year to look at those issues. Without question, and without opining about whether they did or didn't fail their membership, there's no question that for the vast majority of workers in the United States, 94%, in fact, of private sector workers, you're on your own. So whether you disagree or agree with whatever a union might have bargained for in a particular case, at least you might say that there is some group of folks who are trying to advocate for the interests of their members. But just to continue, we have to have the affordable, accessible, quality childcare. Is key to working parents being able to participate and stay in the economy. And we also obviously must have family-friendly policies in the workplace, many of which are what the kinds of policies that Katie talked about. That includes paid leave with job protection. It includes pregnancy and lactation accommodation. It includes policies against discrimination. In the United States, it's very interesting. We were a pioneer on recognizing. It took several decades and a few Supreme Court cases gone awry, and then a law that passed in 1978 finally to recognize that discriminating against pregnant people is a form of discrimination based on sex, because pregnant people are usually of a certain sex. Now, believe me, that actually was not the case until 1978, when the Pregnancy Discrimination Act was passed. Courts did not recognize that pregnancy discrimination was a form of sex discrimination. But we see still now, and it's reflected in the gender wage gap, which is the difference between what women earn full-time, when they work full-time year-round, what women and men earn, and that those disparities between full-time workers are even much, much bigger for Latina and African-American women than for white women. And in fact, Latino women in California have suffer the worst gender wage gap of any group in the country when compared to white men. So full-time working Latinas in California earn on average approximately 43 cents on the dollar earned by full-time working white men. Now, a lot of that is not only because they are being paid less when they do the same job. It is because Latino women overrepresent the lowest paid jobs in the state and are underrepresented in the high-paying jobs. But that in itself is a reflection, as I said, of a minimum wage that is a poverty wage. 2/3 of minimum wage workers are women. So when we're talking about raises to the minimum wage, we're talking about raising the wages of women who, as I said before, are more and more likely to be supporting families, not working for pin money, as people often called it back in the 50s, when the majority of women who worked were black women. So we need those policies that protect people at work from unfair treatment, from being pushed off the job when they become mothers, before they're ready to leave, and from being kept from advancing once they get back to work, because we all know that caregivers, men and women, face a lot of barriers to economic advancement and opportunity, but women really pay the price much more harshly than men. And in fact, there have been studies shown that when men become fathers, they are more likely to get an increase in pay, the sort of fatherhood bonus, because they are seen as and recognized as like breadwinners, like, oh yeah, we have to support this guy even more because he's a father now. Mothers, on the other hand, are often doubted in terms of their commitment. They are no longer given access to the prime assignments and sort of put on the mommy track, as it were, and so face a gradual slowing, if not downward, trend in their earnings. So we have the motherhood penalty that we have to deal with, and there are laws that say that you're not supposed to discriminate based on these gender stereotypes, but there is no, right now in California, and we have tried before with legal aid, and we will try again. We have tried before to get our anti-discrimination law to actually add caregiving or family responsibility status as a protected status, so that you literally couldn't be discriminated against for being a mother, a father, or the primary caregiver for a sick relative. But we have not been able to do that yet, and I think that hopefully under this administration we might have a little better luck in pushing that kind of a legislation forward. But nationally we have no such protection. Some states have adopted those laws, but again, recognizing that people who are caregivers and parents need to have protection of their rights as workers. That is something that is on the horizon and hasn't been accomplished yet. And lastly, what working parents need is a functioning safety net and a path out of poverty. They need to have access to build assets. We have a tremendous wealth gap in this country, and I won't even cite all the statistics, but we have to understand that all of these policies that allow for more workers to have access to paid leave, that raise the minimum wage, but also that cover more workers, that make sure that domestic workers, like here in California a few years ago, we actually passed a Domestic Workers Bill of Rights, which for the first time, brought millions and millions of almost all women, and mostly women of color, into the protections of laws that they had literally not been covered by at all before. So we have to understand that when we do that, we are actually addressing, when we are addressing poverty, we are in fact helping working families and working parents to access the economic opportunity and the economic freedom that I think we all want to enjoy, and we all need in order for our communities and our economy to thrive. So there are some national campaigns that are working toward all of these goals. There is in fact going to be a new law that takes effect this coming year that will open up access to paid family and medical leave for federal workers for the first time. So that will be extremely helpful for federal workers. We have unfortunately, seen a real stagnation on raising the federal minimum wage, which, as you may know, is only $7.25 an hour. And we're seeing a tremendous, just alliance between all kinds of groups that recognize that we're never going to see anything like gender equality or racial justice, or an economy that actually works for all of us until we raise the floor above poverty for working people, and until we provide universal access to paid leave for all parents and caregivers who work. So I think I will leave it there for now, and then maybe Katie can join me on the dais up here, and we can both answer questions and or tell you a little bit more about some of the things that we're excited about coming up in the next year. So thank you very much. I did want to just visually point out that the Stronger California Advocates Network, we have a website just for that, and if any of you are interested in learning more about the legislative agenda, which we are in the process now of planning what the agenda for 2020 will look like. It's basically a platform that has bills, proposed legislation on various things that relate to economic security for working families in California, for women and working families. Fair pay and job opportunity bills, workplace justice bills are one pillar. Family-friendly workplace policies, and those include, paid leave-related policies, are another pillar. Affordable and quality child care is another pillar. And the fourth pillar is anti-poverty measures, income support, and asset building. So if you notice that the pillars sort of follow what my little spiel was just about, that's not a coincidence. This is a description here of the bills that were introduced as part of our agenda this year. And we really would love to have more individual parents, community members, service providers, and organizations join the network of Stronger California Advocates to get updates about where different policies are in the quagmire of the legislative process, and where there are opportunities to come and either show your support or just send a quick letter or sign a petition or do a little tweet to your legislator to say, hey, this is your assembly person or state senator. This is a really important bill. My community cares about this. My organization supports it. There are opportunities like that, so you can sign up for our mailing list to get our emailing list to get more information about that. So if anyone's interested, or on behalf of your organization, you want to find out how to become part of the network, the roundtable, just come up and see me afterwards.
Great, thank you. So we wanted to take your questions that both can answer, and I wanted to just start off, Katie, you had mentioned earlier talking about employers with 5 or more, and I know a lot of the people we work with, the women we work with, might work in just 1 or 2. For instance, someone that goes and does house cleaning by themselves or with one other person, and lots of other situations. What happens to those people who either work on their own or with employers with less than 5?
So that's a good question, and it goes to what are currently some of the holes in the law. So the one that says, okay, you have to give people time off when they need it because of their pregnancy, it does say there has to be at least 5 employees. Now, we have like a state constitution that says don't discriminate against people, so sometimes like we can get creative, point to the Constitution and say that, you know, there's something going on that shouldn't be, but there's nothing really that like the worker can just like point to and be like, look, no, that's not what you're supposed to do. So it is a pretty significant gap, as well as the fact that independent contractors are not covered by any of these. And as I'm sure some of you heard, you know, like a year ago, there was even more recently than that, like a couple of months ago, a new bill that said more people who we currently call independent contractors are actually employees. But what that's going to look like in practice is something that we still haven't seen. We haven't seen the fallout and what that'll look like. But
Yeah. Just to add on to that when you're done, yeah.
okay. But I was going to say one of the things this does bring up is kind of what it is that we're working towards and what the goal is. And so, as I mentioned earlier, the governor has a task force this year where he brought together worker advocates, people from early childhood, including First Five, as well as employer groups to talk about this and see, okay, what's wrong with paid leave in California and what do we need to do to fix it. And they're going to come out with recommendations sometime within probably the next couple of weeks. So what our hope is and what we're pushing for is that the goal is that job protection, so the ability to take time off and have your job there, that should be universal. It shouldn't matter how long you've been working somewhere, it shouldn't matter how many people your employer has, that should be universal. And then as far as getting paid when you take time off, you should get paid more because there's lots of people who can't afford to take time off at 60% of their pay. So right now we do have those gaps, but you know, what you said, it really kind of points to what that gold standard is and what we're all working towards and hopefully more what we'll see in the next couple of years.
Great, thanks.
And I was just to clarify and add to that you know, one of the biggest challenges that we face in our working parents also include you know, gig economy workers. We have more and more millions and millions of people who are sort of, whether they start off doing it as a side hustle, as they call it, or it is their only source of income is by doing these jobs where they get paid either in cash or the equivalent of cash, or they are actually working for a big company like Uber, Lyft, DoorDash. You know, millions of people are working for these companies where they are classified as independent contractors. In other words, they're not employees at all. So none of these rights and protections that we've talked about, absolutely none of them apply to them. And in fact, under California law, one of the only employment-related rights that independent contractors have is the right not to be sexually harassed. So even if you are a house cleaner who works for one person, and that person is your employer, or you are providing services to them, they are not necessarily treating you as an employee, you still have that right. But other than that, the access to paid leave, it still depends on your job and your location, just generally, and in the big high in the sky where we're headed, you know, hopefully one day in California certainly, and then perhaps in the rest of the nation, we will have the ability for workers to be able to access paid time off, regardless of who they work for or whether they work for themselves or an employer.
So would you both suggest for someone that is a single individual working for a family, for instance, as a nanny or a housekeeper, would you suggest that they at least start off, as you said before, Katie, just with a friendly request, when notifying them, either I'm pregnant or I'm pregnant, they'll know at some point, I have a due date at this time, I would like to take this much time off, I hope I can come back to my job in 4 months, or...
Yeah, that's a good question, and because there aren't those legal protections there, it really does kind of come down to practical common sense. So, you know, asking people for something, giving them notice, you know, being friendly. Unfortunately, because you don't have the law backing you, those are the tools that you have. So, you know, when people call and the law doesn't apply, you know, still it's worth, you know, talking through and thinking about, okay, like, you know your boss, what do you think they'll do? Like, what do you think is the best way to approach them? So I think that's right.
And I would also add to that, you know, that's the power of unity and collective action too, is that if you are a worker, a housekeeper, a nanny, you do provide, you work for people in their homes, look to your local organizations that might provide a space for you to join a coalition, for you to join a colectiva. You know, there is in Oakland, Mujeres Unidas y Activas houses a colectiva of women who are working in domestic work and also in other areas. And you know, perhaps you can propose that someone, you know, maybe you have a colleague, a compañera who can fill in for you, and you can propose that to the employer, like, while I'm out, you know, I'd like to introduce you to my colleague who will take over for me for a few months. But again, that comes down to where can you find a little bit of power where you don't really have much leverage or actual legal rights, you know. Obviously, most families really depend on their domestic work employees. They're the people who provide house cleaning and childcare are crucial to their own ability to do their jobs and to live their lives. So, you know, that everybody, you know, has a stake, I think, in trying to make it work. So I think, you know, absolutely, like, even if you don't have the legal right to try and come up with some ideas collectively with others, as well as through communication, direct communications.
Great, thank you. We have another question here.
Are you familiar with IHSS? In-home support services? That is a catch-22.
What is IHSS?
In-home support services. And
Home health care.
home health care services. The problem there is the caregiver is employed by the individual, was paid by the government. So it's a catch-22 on who represents them. And out of 50 counties, not every county is the same with IHSS. So how will you provide services that'll balance it out statewide?
Well, I think, again, just sort of, since we're here talking from the perspective of working parents, I think, you know, and also, you know, working people who have caregiving responsibilities, you know, many of the IHSS workers are themselves parents too. And again, most of them, I think close to 90% of them are women, and many of them are single moms. And so again, ensuring that, but many of them are actually classified as independent contractors. So there are some really thorny legal issues around, like, who's responsible for making sure that those caregiving providers have decent working conditions, and also that the people receiving the services, the disabled people, the people who have medical conditions, seniors who are being served by those people, that they don't you know, face, you know, disruptions in their much needed care. It's a very difficult balance, and you know, I think there are some efforts to, like, sort of look toward some policy solutions, but also, again, toward, you know, enabling those workers to have some kind of collective, a way for them to collectively bargain. But it's tough. Yeah.
Yeah, I think you said it. Yeah, there's been a lot of movement around unionizing for those workers recently, but then, I mean, it even kind of made it up to the Supreme Court a few times looking at it, and there's a lot of bad union answers at the moment. It's a rough spot.
Other questions?
Hi, so thank you both for your presentation. I am a good example how the safety net can be beneficial. So in my case, I was actually on unemployment when I was pregnant, and I was able to take advantage because I was unemployed and getting paid at the time, but the benefits that I was having, that I also had the ability to tap into. I don't know if it was a paid family bonding, but that was something that I didn't even know that I had the ability to do, even though I was getting paid by the state for unemployment. And that allowed me, after that, to be able to build a little bit of security for me and my family, and stay with my child for about a year until I went back to work. But in so many ways, until you become a parent, you are actually become aware of so many issues. So one example of those is that realization that in order for me to go back to work, I have to rely on somebody else to take care of my child who's being underpaid, who is actually not being recognized for the work that they're doing. And I think some of the failures as a feminist myself is that we have broken so many barriers in the workplace to have women be at the workplace, but without recognizing that it has been in the back of people, most of them women of color, who have allowed white women and people in a privileged position like myself to actually go back to work. And I think if as people that look into gender equality does not address issues around racial disparity, particularly when it comes to advancement in the workplace and why we are there to begin with, I think it would be very difficult to find allies to move the agenda forward for all the other issues that you mentioned around poverty, around living wage, and around getting people in the childcare industry and domestic workers to actually get equal pay for what the work that they should be doing. And I would like to know your opinion about how, as counties, for example, we can, you said San Francisco is at the forefront in many ways, but I wonder if us as county in Marin could actually invite our own supervisors, or the people that actually write laws and ordinance in the county, to push them to embrace some of this, to actually move the advocacy forward. Is it worth to pushing these things locally in order to get this to advance at the state level and hopefully in the future at the federal level? Thank you.
Yeah, it's a great point and a great question connected with that. And I think it's definitely always worth pushing at the local level, because not only do you set the example for the state, but sometimes things just aren't ready to move at a state level when you still can make that progress at the county. And I think especially when there are laws already in place, like she mentioned that predictable scheduling and fair scheduling in San Francisco, and then shortly after that Emeryville has their own fair scheduling. And I know Berkeley's been looking at doing something similar based on that. So when you have a model that you can point to and find something that you think could work for your community, I think it's always worth talking with your supervisors. Because sometimes progress on the state level is slow, and that way you can build that locally. And then also that's how you kind of get things to a state level. Like, as these policy discussions happen, you see, like, for example, with the lactation bill, like employers in San Francisco who already are stuck with those requirements, who've done them and realize, okay, like it's not actually that bad. You can then come to the state and say, hey, you should do this, because you know what? They don't have anything to lose. They already have to comply. So I think it's always worth fighting for.
Yeah, I would agree that definitely there are many ways in which many of the different kinds of policies, ranging from pay equity related policies to sick leave policies. It always blows people away. I think that the United States, in addition to not having paid family and medical leave, that nobody even has a right to take a day off when they're sick, not even if they work in an industry where they're handling food or taking care of children or interacting with the public in some other way. It's really insane. And how long it took, even here in California, progressive California, to get 3 measly sick days a year. But be that as it may, I do think there were and are and continue to be, states, cities, counties all over the country where these really fundamental but basic sort of rights and protections have been advanced. And I just want to say I also agree, 1,000% with everything that you said at the beginning about the need to address these issues as both a gender and race issues, racial justice and inequity, and recognize that, I mean, there is a reason why, the reason why our existing minimum wage laws and overtime laws and anti-discrimination laws, don't apply to caregivers, farm workers, and other huge categories of working people, is because when those laws were passed, the only people doing that work were black and brown women, and some black men. And so there is built-in racism into our laws themselves. And in order to disentangle that and to actually push forward anything like, equality for women and men generally, we have to recognize that the labor of women in this country has been systematically undervalued in many, many ways. And so, that's why eliminating the sub-minimum wage for tipped workers, that's an economic security issue for working parents. So all of these things are connected, and I just thank you for raising that.
Thank you. Other questions? Questions from the clinic?
Oh, y también quería decir si alguien tiene una pregunta en español, yo
Sí.
puedo responder.
Okay.
The microphone is good for people that have disability with hearing. So sometimes we're shy, but if people cannot hear, it's important.
Can the employer change your position if you go on leave, on pregnancy leave or family leave when you return? Is that legal?
So they have to put you back in, so if it's pregnancy leave, it has to be the same position, the same hours, the same responsibilities. If it's baby bonding leave, it's virtually the same position. So yeah, things can get a little fuzzy. So if they're the same hours and the same pay, then you can end up in kind of disagreements about how similar is the work, but it has to be pretty much basically the same.
For the lactation, the new law that is going into place, does it have to be one designated area, or could they change it? Like one day you go here, the next day is whatever room is available, or?
So it doesn't have to be a permanent space. It can be a temporary space if necessary. But I think because it hasn't come into practice, I think if an employer is really saying switch room from day to hour, I think that's something that they shouldn't be able to do, and I think you could say it's probably not complying. Let's say there's a conference room, or this extra, or what we'll see is a lot of times if people working fast food, it'll be the manager's office. Mm-hmm. So it's not permanently the lactation room, but every time that person needs to pump, they just need to be able to have access to that specific space and to put a sign on it or lock the door and say, okay, don't come in, I need it right now, so now it's lactation space.
Yeah, and it has to be private, there has to be a door, and it can't be the bathroom.
Right.
And there's an interesting issue that I read about recently where an employer was allowing a lactating breast pumping employee to use a manager's office, and I think it was even in the back of a restaurant or something, but that office was equipped with a surveillance camera. And so the employee had to ask, okay, not only do I need to use that office, but you need to turn off that surveillance camera for 10 or 15 minutes. And there was a verbal tussle, but I think eventually the employer conceded, okay, you're right, it's not really private if someone can watch them on video.
Right. And my last question is, sorry, we had a few. There was you mentioned that they have the right to take time off if there's like a DV or something like that, right? But do they have to disclose it to the employer that is for those reasons? Because that's a very...
Yeah, no, that's a good question. So it's interesting that you asked that because so first in California we had laws that you can take time off because of domestic violence and because of seeking shelter. And then a couple of years ago there was an employer who fired somebody. And then the employee said, okay, you can't fire me. It was you can't fire me for taking time off to seek shelter. And the employer said, it's not because he took time off, it's just because you're a survivor. So then they changed the law. You can't discriminate against somebody for being a survivor. But what we always kind of think about is, so you have to have some basis for the protection. So if it is you're taking time off under the law to go to court to get a restraining order, you do have to tell your employer. But the paid sick days that we have in California, so you have 3 paid sick days no matter where you are in the state, as long as you've been working about 3 months. Your employer isn't allowed to ask for a medical certification if you're taking only less than 3 days off. So sometimes, I tell people, it's up to you, and you can think about it maybe you want to say that it's a sick day. Maybe there's an alternate basis to get that time off, but to have your job protected, there has to be a trigger. So whether it's a sick day as the trigger, or whether it's actually going to court, or sometimes for people who have to go to counseling for what happened in domestic violence, you have the choice of saying, okay, is it for a disability or is it for domestic violence? But there are ways that you can kind of decide between whether a health track or a domestic violence track. But if you just take the time and don't tell your employer, then you're completely out of luck.
Okay. So I would add that law that she's talking about also applies to victims of sexual violence and stalking that isn't related to domestic. It doesn't have to be someone with whom you're living or who's your domestic partner. You could have suffered sexual assault from someone else, including someone at your workplace. And oftentimes I'll just say that some of the pushback from employers comes when, if someone is experiencing domestic violence or intimate partner violence in the form of stalking, if their partner is coming to the workplace, then the employer has perhaps some legitimate concern about the safety of other workers, right? And so there is a requirement that in the law that there has to be reasonable accommodation for workers who are facing domestic violence issues. And so it's really, ultimately, if you're struggling with these issues and you need some kind of either time off, or you need to, for example, you need to ask to be placed in a different area of the building, or you need to not work certain hours because you're being stalked. Those are the kinds of things that you do have a right to ask for, and the employer has an obligation to engage in a dialogue with the worker to figure out what they can reasonably accommodate. But it is often scary, and a worker is going to want to be able to access not just maybe legal counseling, but seek the support of an organization that supports survivors of sexual and domestic violence. So there are community resources out there, certainly here in Marin County and other places, but to be able to engage in that dialogue is very overwhelming for people who are actually in that situation. Yeah. So.
Okay, thank you. We have 3 more questions.
Yo tengo 2 preguntas, una es personal y otra es por alguien más conocido. La mía es, yo soy ama de casa, yo nunca he trabajado fuera de casa, dependo de mi esposo, y yo quiero saber, nunca sabe uno qué pasa si él llega a pasar algo o una separación o algo, qué derechos tiene uno. Tengo ya 26 años casada y qué derechos o...
So first I'll just translate her question, basically, well, her first one. she said she has two. One is personal and one is on behalf of someone else that she knows. And the first question, which I'll let Katie respond to, is she said, I'm a housewife. I have worked. I've worked at home. I've been for over 26 years of marriage. You know, what rights do I have if something were to happen to my husband, or and tal vez entiendo qué derechos tiene él o qué derechos tiene usted. Yeah. So what rights does she have in terms of
If something happened to her husband.
right, derechos en cuanto a como beneficios o
beneficios o si hubiera una separación de matrimonio también para mí qué beneficios tendría o no tengo nada.
Or if they separate.
Right, or if they separate, sorry.
Case of divorce,
Yeah, I
that's
mean,
what she
that's
said.
a good question, but yeah, unfortunately, my area is employment, so I don't have a great answer for you, but Bay Area Legal Aid, they're another great organization, and Legal Aid of Marin, and they have more expertise in like different benefits that people can get, and also might be able to help with family law questions, so I suggest reaching out to them.
Yeah, solo para decirle que la pregunta trata de una cuestión de derecho de familia, como de cuáles beneficios o protecciones tiene uno cuando se separa o se divorcia de su compañero o su compañera. Del Estado, usted no va a tener ningún beneficio directo, pero para apoyo financiero de él, es muy posible que usted podría tener derecho a pagos de alguna forma de él. Pero eso es una cuestión un poco fuera de lo que Katie y yo no somos expertas en eso.
Sí,
pero,
sí, la pregunta es porque, o sea, hablan de los derechos del trabajo y todo, pero es que trabajamos dentro de casa y no recibimos. Y la segunda es de una conocida, ella estaba trabajando para un lugar donde cuidan adultos, ancianos, no tiene documentos, creo que está en proceso. Su esposo ya tiene residencia. Y yo le dije del programa del LIF que les pagan a las personas, ella dijo que porque no tenía documentos, no tiene seguro bueno, no le podían dar. Y el niño tiene apenas 9 meses. Y ella ahorita dejó de trabajar porque pues para cuidar al niño y como no recibe beneficios, es la pregunta.
So her question is, she has a friend who works at a senior care facility who's undocumented. She's in the process of, changing her status, but her husband has permanent residency, has documents, but, she's not working with a good social security number, and so she's under the impression that she doesn't have the right to any kind of benefits, or to try and get any kind of benefits, and her baby is only 9 months old, and so she just left her job and isn't, getting any. La pregunta tiene que ver con si ella tiene derecho a beneficios del Estado, como de seguro del Estado, o porque es probable que ella ha pagado bajo ese número de seguro que no es bueno, pero si ella ha pagado al fondo del Estado, que ella podría sacar dinero de eso, pero, so I was saying, like, if she paid into the fund under that Social Security number that she's working with for now, it's possible that she actually could get the money because it's supposed to be a social insurance program. It's all paid for by workers. The employers don't pay anything into that fund.
And it's 6 weeks, and she can take it any time before the baby turns 1.
Yeah, so 6 semanas y por ahora hasta el julio del año que viene tiene hasta 6 semanas que puede tomar uno de beneficios de family bonding, or family paid parental, family leave, sorry, so many different. Pero puede tener estos beneficios, puede acceder a estos beneficios hasta que el bebé tiene 1 año. So, todavía tiene tiempo ella. Si quiere más información puede comunicarse con Legal Aid at Work.
Okay, gracias.
Just to add, solo para añadir que Legal Aid of Marin,
Yeah.
solo para añadir, I just wanted to add that Legal Aid of Marin, que es una organización legal aquí en Marin County, está haciendo ahora consultas sobre beneficio público. So Legal Aid of Marin is now doing consultations around public benefits. So they will be able to assess, van a poder analizar su caso, will be able to figure out if they actually will qualify for benefits, or the child who probably qualifies for CalFresh because as a U.S. citizen it may be also on the poverty level and qualify. Entonces puede ser que hayan otros beneficios donde la familia también pueda aprovecharse. Pero Legal Aid of Marin could actually now answer those questions.
That's great.
And I'll provide that contact information to you, Hilda, that you can share it to everyone. So I'll send a follow-up email with the documents and all the contact information. Okay, ¿uno más?
Yo tengo una pregunta. Yo trabajo babysitter y housekeeper solamente con una persona. Estoy siempre dentro de la casa de ella. Mi pregunta es, yo acabo de tener mi bebé, pero yo nunca le dije a ella, como no tengo contrato, no tengo ningún social security con ella, entonces solo tengo el trabajo de hablado, entonces quería saber si yo pudiera ir a pedirle un pago por algunas, tal vez una semana por dejar de trabajar por mi bebé. Entonces, si tengo yo, si yo puedo pedirle eso a ella.
Do you understand the question?
Yeah, so
Just
if,
for everyone else,
yeah.
I'll just quickly, so she works as a nanny, as a babysitter.
Use a mic.
Oh, sorry. She works as a nanny. She takes care of children and lives with the family that she cares for. And she just had a baby who looks very tiny and cute. But she's never asked for any time off or any paid leave, and she wanted to know, can she ask for maybe, say, a week of paid time off so that she can, spend a little time with her baby.
Yeah, and so unfortunately this is one of the gaps in the law, so you can ask, but they're allowed to say no if they want to. One thing I'd mention is, so if you work somewhere else within the last year or 2 years where you were paying in, then if you take time off, it's worth trying to apply to the state because they don't look at how much you're making today. There's a whole look back period that can go up to 18 months or so in the past. So if you've had a different job recently where you have been paying in and your boss does let you take time off, try applying for paid family leave.
Desafortunadamente, esto es una de las cosas que falta en las leyes, en las protecciones, que trabajadoras como usted, que está trabajando domésticamente en una casa, no tiene acceso a estos programas de beneficios estatales y no tiene derecho legal de pedirle a su empleador el tiempo de ausencia, de licencia. Obviamente, si usted podría pedirle al empleador para este tiempo y para un pago, es básicamente una negociación del contrato de trabajo, pero ellos no tienen ninguna obligación legal de autorizar pero lo que dijo Katie es que si usted ha trabajado en cualquier otro lugar para otra compañía una compañía, un empleador en que usted le pagaba a usted con cheque normal y todo y usted contribuyó al fondo estatal, de Disability Fund. Entonces usted podría tener derecho de acceder el seguro, los pagos, los beneficios, si ha pasado menos de como 18 meses. Porque el Estado no solamente evalúa lo que estaba ganando usted cuando sometes la forma de solicitud de beneficios, pero evalúa lo que ha trabajado la persona como hace un año o un año y medio de atrás. Hasta 18 meses, a year and a half. Like it's like a year and a half. Right?
So would you both suggest for someone that
It's by quarters. It's very weird, but.
would you suggest then that for someone that has a particular need that they come in and have an appointment at Legal Aid of Marin or at Legal Aid at work?
If you have questions, yeah, we're always happy to talk about your specific job and where you've worked beforehand and figure it out. And also we have people in the office who speak Spanish much better than I do, and people who speak Mandarin and Cantonese.
And Jenny, can you just tell her that in español?
Yeah, hay abogados y que hablan español en su oficina, también en la oficina de Legal Aid a Marin, pero como no es exactamente, yo añado que como no es exactamente una pregunta o problema legal, ¿no? Tal vez podría ser que trabajar con una organización como Canal Alliance o otra organización que tiene un grupo de mujeres unidas o mujeres colectivas de mujeres que trabajan en el trabajo doméstico, con ideas y el apoyo de sus compañeras y amigas, tal vez eso es una mejor solución.
Thank you, gracias. We have time for, we're past our time, but one more question.
Thank you. My question is, what about if the employer doesn't have the money to pay monthly, let's say the salary for this month or 2 months, right? And then they decide to reduce the salary, and then they say, oh, we're not gonna pay the full salary this month because we don't have the money, but we will refund that money and in 2 months and 3 months. Is that legal? Or
Like in general, like
in
can
general.
an employer just like reduce your salary without warning?
Yeah, I'm asking that because some of the folks that I work with sometimes come to the office and they say, oh, my boss is not gonna pay me the total amount that they had to receive because they don't have money. So, and they say they're gonna pay me and the next month the money that didn't pay me this month.
Yeah, so they have to pay.
Yeah,
they have to pay, and
they do have to pay for the work that's already been done. So if you agreed in, June to start working at this job or took this job and you agreed to work for $15 an hour and then you worked 50 hours, you're entitled to $15 an hour for all of those hours that you worked. Now, if you show up at work one morning and the boss says, actually let's say it started at 18 because 15 is getting close to the minimum wage, and your boss says, look, funds are low, so if you, from now on, from like right now forward, I'm gonna only be able to pay you guys $15 an hour, I'm sorry, and you were making 18 before. You going to work and then working is your agreement to that new wage. So it's, again, this is assuming, by the way, there's no union. I don't think anything like this would ever be able to happen in a unionized workplace. But yeah, so you're basically, for the most part, employers can unilaterally decide to reduce your salary, at any time, and your solution is to either try to negotiate a higher pay or to leave, right? And of course that's that's a catch-22 situation for most people. But for sure, they cannot change the wage rate after the fact. They can't say, oh, less money has come in from customers than I was expecting, so for all that work you all just did, I can't pay you $1,000, I can only pay you $800. No, that's, can't do that. And if they don't pay up, immediately, actually, you could bring a claim to the Labor Commission to seek the unpaid wages with interest and potentially with some penalties as well, which.
And just like I'm on our like work and family team at Legal Aid at Work, we also have a wage and hour team where if anybody's being paid less than minimum wage, or their employer's not paying all their wages, or they're paying late, or cutting an hour here or there, or not paying overtime, they'll go through with them and like help work together to figure out all the money that your employer owes and figure out how to file it with the state to try to get that back.
Can I just follow that? What about if they claim bankruptcy, that company?
Oh, bankruptcy.
Yeah,
The whole bankruptcy system is set up to benefit the rich and corporations, I'll just say that. But if an employer actually declares bankruptcy, like actually files for bankruptcy, there is a way for workers who have been employed up until, for a certain period of time right before. Workers are considered, creditors they get some priority. It's complicated, but you can make a claim as a worker who's owed wages. You can put a claim in at the bankruptcy court and say, I'm a worker who was employed in the last 6 months before they filed bankruptcy, and I should get priority in the line, because you're going to have to get in line after all those other creditors of that employer who may have preference over you. Like if they owe money to a bank, that bank probably has preference, but the workers are supposed to be, at least 6 months before that, they're supposed to be at least pretty high up there in the preference. But it will take a while, I'll tell you that.
So it's not great, but practically considering, that is something to think about. It's one thing for the state to say, okay, even you go through the whole process and the state says, okay, employer, you owe them $100,000, but if they don't have the $100,000, then maybe you end up in this process and it takes a long time. So, there's some extent of thinking about what's best for whoever that individual is at that moment. And it doesn't always feel like justice, but if their employer is willing to pay them, $40,000 at the moment, and then they can get that now. For some people, that's unfortunately the better choice. So it's just something to think about.
And also just at the front end, if you, when you're thinking about, if you're already in a situation where your employer is not paying you or owes you money, that employers may have some kind of company that they've incorporated or established that is paying the paycheck. And that company may go bankrupt, but the individual employer maybe is still out there, driving fancy cars and buying another house or whatever. So it's important to bring the claim against the individual owner too. So anyway, basically seek legal help from the get-go.
I'll just say, wow, thank you.